Hello guys, hope you're having a great day. Welcome back to the next session of this course. So today we'll be starting with trademarks in depth. So in this session, let's start with the basic foundation and introduction of trademarks. Now, when we talk about the basic meaning and definition of trademarks, then according to the Trademarks Act of 1999, especially section 21ZB, it is basically a mark capable of being represented graphically and capable of distinguishing goods or services of one person or brand from those of others. So what do we learn here? There are certain elements which we have to talk about while considering whether something is a trademark or not. So, when we talk about elements of this definition, then a trademark should either contain a mark, which can include a brand or heading or label, signature. It could be a word, letter, or it could be numerical in nature. It can be a shape, or it can also be a type of packaging. It can also be a combination of letters as well. Then second thing is that it must be capable of graphical representation. So it must be presentable in a 2D or a 3D plane. It should be basically tangible. Then the third thing is that it should be capable of distinguishing goods and services, which means that if you look at the Cadbury purple color, then you'll instantly know that this color is associated with the Cadbury chocolate. Now, there are certain conventional marks which include words, logos, or slogans. So, words like Tata, like we have talked about Nike swoosh logo, or slogans like just do it. They are all considered as conventional trademarks. Now, there are certain non-conventional marks as well, such as types of sounds or types of colors, like we have talked about the Cadbury one, or if you talk about the Nokia phone's tune, then these can be considered as trademark sounds. Then we can also talk about shapes of different goods, like in earlier session we talk about the Coca-Cola bottle's contoured shape. Then that can also be you can also consider a specific type of scent, although that is not applicable in India, but in a few countries it is. Now after this, when we talk about the function that a certain trademark holds, so the first one is that it can act as an indicator of a product's origin. It acts as a symbol of quality. It acts as a medium of advertising, and most importantly as a legal shield. So when we talk about indicator of an origin, so trademark can be considered as a shortcut in consumer decision making. So instead of analyzing every little feature about a product, once you see a trademark of a certain popular well-known product, then you can easily automatically trust it, and buyers rely on such marks. So for example, instead of looking at a car and noticing every little tiny minuscule feature that it holds, if you just see that it has a Mercedes logo, you know that it's going to be of top-notch quality, and so you will not think much about whether it will serve you purposefully or not. Now, when we talk about the objectives that a trademark holds, then firstly, when we look at it from a business perspective, then it builds goodwill among different businesses. It also secures customer loyalty, and it differentiates your brand from your competitors. Then when we look at it from a consumer perspective, then it provides an assurance of consistent quality, like we just talked about in the car example. Then it also protects consumers against confusion between different brands, and it also acts as a guide for repetitive purchasing. So if you have bought a Nokia phone and you are very well happy with the purpose that it fills, and then if you go to a shop and you see a Nokia phone, then you know that it's trustable. Then when we talk about economic perspective, then it prevents unfair competition, and it encourages innovation and branding investment. Now lastly, when we talk about a trademark as a property, then it acts as an intangible asset, and in a few cases a trademark can also be valued higher than the actual tangible product. For example, if you talk about a trademark of the Apple company or that of Coca-Cola, then of course it is very easy to imagine why the brand or that trademark would be, much more valuable than the actual product. Okay, now let's talk about a brief evolution of trademark law in India. So firstly, let's start with the pre-statutory era, and it was governed only by a common law principle of passing off. Now, what do we mean by passing off? So, when the trademark has been registered by the owner and some sort of infringement occurs, then it becomes a suit for of course infringement. But what happens in the case where the trademark has not been registered prior and then an infringement occurs? So in that case it becomes a case of passing off. So basically, the principle of passing off is that nobody has the right to represent his goods as the goods of somebody else. And it was decided in the case of Perry versus Truefitt of 1842. Although the passing of law has, altered over time. Then after that came the 1940 Act, which provided the first statutory recognition, and it was modeled after the UK law. After that, Trade and Merchandise Marks Act came in 1958, and it sort of consolidated the trademark law, including the provisions for registration, offences, and enforcement of trademarks. Then finally came the Trademark Act of 1999. Now it did a lot of things. So firstly, it enacted to comply with the TRIPS agreement of 1995. Secondly, it recognized service marks for the first time. Now also when we talk about service marks, it is basically a type of trademark which is used in some countries to identify a service instead of a particular product. For example, service mark of Starbucks or Urban Clap, so things like that. Then it broadened the definition to include unconventional marks as well, which we talked about. Then it introduced the concept of well-known trademarks, and it also established the Intellectual Property Appellate Board, which was later merged into High Courts in 2021. Now, lastly, let's talk about the sources of trademark law in India. So, firstly, we have the statutory law, which is the Trademarks Act of 1999. Along with, we also have the Trademarks Rule, and it was very recently amended in 2017. Now, these two form the backbone of the trademark regulation in India. Then, after that, we also rely on certain judicial precedents. And a very famous example of a precedent is that of Cadila Healthcare versus Cadila Pharmaceuticals case of 2001. So basically what happened here was both companies used the name Cadila and both of them launched an anti-malarial drug. So one company launched a drug called Falsigo and the second company launched a drug called Falsitab. Now the problem is that similarity between both of them was so striking that it posed the risk of confusing patients between both of these drugs. Now, after that, the lower court and the high court sort of dismissed the claim, but the Supreme Court highlighted certain key tests for a deceptive similarity. Now, what is deceptive similarity? So, it occurs when one trademark is so close to another in look or sound or meaning that it is likely to mislead an average consumer into believing that two goods or services, they both come from the same source. So basically, if a consumer of average intelligence or average memory, they could very easily mistake one mark for the other. So that is basically called deceptive similarity. So when we talk about the case of Falsigo and Falsitab, then deceptive similarity can be implied there. So basically, yeah, like we were talking about, Supreme Court highlighted certain key tests to identify deceptive similarity. So first we look at the type of mark. Then we look at phonetic similarities or visual resemblance. Then we look at the nature of goods. We look at the class of buyers or the target consumers. We look at the level of care, the mode of purchase, and different surrounding circumstances. So basically, the court stressed that when we talk about healthcare or the medicine industry, then it is of course a very risky business. So even some minor confusion can endanger public health. Hence, This case set the precedent or the benchmark for how Indian courts assess trademark disputes in such sensitive sectors. Then the third point is that of common law principle of passing off, which we have already talked about before. So basically, even if a trademark is not registered, businesses can still protect themselves against other misinterpreting their goods as those of the original owner. Then finally, there are certain international sources as well. So, India is a party to the Paris Convention of 1883, which provides protection for industrial property. Then, the TRIPS Agreement of 1995, it also sets minimum universal standards for certain trademark protection. And also, since 2013, India has also been part of the Madrid Protocol, which allows for a single international application to secure trademark protection across multiple countries. Alright, so basically, when we look at trademarks in India, it is not just situated to the domestic law, but also case laws and international agreements. Alright, I really hope this session was easy to understand and interesting. Thank you so much for coming today. My name is Bhargavi and this is Vaquill.